Imagine receiving a legal document in the mail. It looks formal. It looks expensive. It says someone is suing you, and your instinct, the very human instinct, is to put it down, walk away, and hope it somehow resolves itself without your involvement. A lot of people act on that instinct, and a lot of people regret it in ways that take years to undo. Because here is the thing about a lawsuit. Ignoring it doesn't make it go away. It makes it worse. Specifically, it hands the person suing you a legal mechanism that lets them win automatically, and then go after your bank account, your wages, and your property without ever having to prove their case in front of a judge. Understanding how that mechanism works and what your options actually are is one of the most practically important things you can know. When someone decides to sue you, the process formally begins when they file a complaint with the court, and you are served with legal notice. That notice, commonly called a summons, is not a threat. It is not a warning. It is the official start of a legal proceeding in which you are already a named party. The summons tells you several things: who is suing you, what they are claiming, and critically, how long you have to respond. That response deadline is not flexible in the way most people assume. It is a hard legal deadline set by court rules, and it typically runs somewhere between 20 and 30 days from the date you were served, depending on the jurisdiction and the type of case. Some cases have shorter windows. The specific timeline varies, but the structure is the same everywhere. You have a defined period to appear and respond, and once it passes, the consequences begin. Being served doesn't always mean receiving something in person. Service of process rules vary, but courts have mechanisms to ensure that legal notice is considered delivered, even if you were difficult to reach. Claiming you never received the papers is a defense that courts examine carefully, and one that becomes harder to sustain the more time passes without a response. If you fail to respond to a lawsuit within the required time frame, the party suing you can ask the court to enter something called a default judgment. A default judgment is a ruling in the plaintiff's favor, not because they proved their case, but because you failed to contest it. The court treats your silence as concession. In many cases, the judge doesn't even conduct a full hearing. The plaintiff presents their claim, you're not there to dispute it, and the judgment is entered. That judgment is a legally binding court order stating that you owe a specific amount of money or that a specific legal outcome applies to you. It carries exactly the same legal weight as a judgment entered after a full trial. The fact that you never had a chance to tell your side of the story is, at that point, largely irrelevant. The deadline passed. The judgment stands. And here is where the consequences become concrete. A judgment is not just a piece of paper. It is a tool the winning party can use to collect what they are owed, often without asking you again. One of the most common collection mechanisms is wage garnishment. With a valid judgment, a creditor can obtain a court order requiring your employer to withhold a portion of your paycheck and send it directly to them. In the United States, federal law caps the amount that can be garnished from wages in most cases, but the portion that can be taken is significant, and it continues until the debt is paid. Your employer is notified. Your paycheck shrinks. You don't get to decide when or how. Bank account levies work similarly. A creditor with a judgment can, in many jurisdictions, obtain an order that freezes and seizes funds directly from your bank account. You may wake up one morning to find your account balance depleted, legally, and without prior individual warning to you, because a judgment was entered against you months earlier that you never responded to. Property liens are another tool. A judgment creditor may be able to attach a lien to real property you own, meaning if you sell or refinance, the debt must be satisfied first. In some jurisdictions, liens can eventually lead to forced sale proceedings. The specifics vary enormously by location and the type of property, but the principle is consistent. A judgment gives the other party legal access to your assets that they did not have before. And judgments don't disappear quickly. Depending on the jurisdiction, a court judgment can remain valid and collectible for years, sometimes decades, and can often be renewed. Interest may accrue on the unpaid amount throughout that period. Beyond the immediate collection actions, a judgment against you can affect your financial life in ways that extend well past the original dispute. In many countries, court judgments are matters of public record and can appear on your credit report. A judgment on your credit history signals to lenders, landlords, and other parties running background checks that a court found you liable for a debt you didn't pay. The impact on your credit score can be significant, and the record can persist for years depending on the jurisdiction and credit reporting rules. This has downstream effects. Loan applications become harder. Rental applications face additional scrutiny. In some professional contexts, a judgment can surface in background checks relevant to licensing or employment. The financial consequence of ignoring a lawsuit isn't limited to the amount being claimed. It ripples. This is the question most people ask once they realize what has happened, and the honest answer is sometimes, but it is not easy, it is not guaranteed, and it gets harder the longer you wait. The legal mechanism for challenging a default judgment is called a motion to vacate. You are essentially asking the court to set aside the judgment and allow you to respond to the original lawsuit. Courts have discretion to grant this, but they generally require you to demonstrate two things. First, that you had a legitimate reason for missing the original deadline. Courts recognize valid excuses: serious illness, never actually receiving proper service, a genuine emergency that made response impossible. What courts are far less sympathetic to is simply having chosen not to engage. Saying you found the lawsuit overwhelming or that you hoped it would go away is not typically the kind of reason that moves a court. Second, that you have a meritorious defense, meaning that if the judgment were vacated and you were allowed to respond, you would have something substantive to say. You don't need to guarantee you'd win, but you need to show the court there's a real defense worth hearing. A court is unlikely to undo a judgment just to reach the same outcome after a full hearing. Timing matters enormously here. The sooner you move to vacate after discovering the judgment, the better your chances. Courts become increasingly reluctant to disturb a judgment as time passes, especially if the winning party has already taken collection steps in reliance on it. Waiting months, or discovering a judgment years later, makes the procedural path significantly narrower. Understanding who ends up in default judgment situations helps explain why it happens so often. Debt collection cases are among the most common. A creditor or debt buyer files suit over an unpaid balance. The amount may seem manageable, or the defendant may feel the debt isn't valid, or they simply don't know what to do with the paperwork. They don't respond. A default judgment is entered. Now a debt that might have been disputed or negotiated has become a court order with collection powers attached. Small claims court is another common setting. The informal nature of small claims leads many defendants to assume the process is similarly informal legally. It isn't. A default in small claims court is still a judgment with real enforcement consequences. Business disputes catch people off guard too. A sole trader or small business owner gets served in connection with a commercial dispute and assumes they have more time than they do, or assumes the matter will settle without formal engagement. The clock runs regardless, and in all of these situations, the underlying dynamic is the same. The person being sued had options: to dispute the claim, to negotiate, to appear and explain their position, and those options expired unused. The single most important step is also the simplest. Do not ignore it. Even if you believe the claim is wrong, even if you think the amount is inflated, even if you can't immediately afford a lawyer, the worst legal position you can be in is a default judgment. Almost any other position, including contesting a claim you're not sure you'll win, is better than that. Read the papers carefully and note the response deadline immediately. In many jurisdictions, your first step is filing a formal written response with the court, called an answer. That states your position. This alone preserves your right to be heard. If the claim seems small enough, small claims court procedures in many places are designed to be navigated without a lawyer. If the amount is significant, legal advice early in the process is almost always worth the cost. Many attorneys offer free initial consultations for civil matters. Some jurisdictions have legal aid services for those who cannot afford representation. If you genuinely cannot afford to respond properly, appear anyway. A court appearance, even an imperfect one, is better than non-appearance. Judges are generally more willing to work with someone who shows up and engages honestly with the process than with someone who simply wasn't there. The legal system is built on the assumption that both sides show up. When one side doesn't, the system doesn't pause and wait. It moves forward and resolves the matter in the other party's favor. That is what a default judgment is. the system, finishing a proceeding that you decline to participate in. What makes this especially important to understand is that the underlying claim doesn't have to be valid for a default judgment to be entered. You could have a strong defense. You could have evidence that would change everything. None of it matters if you never appear to present it. Ignoring a lawsuit doesn't protect you from it. It removes your ability to respond to it. And the difference between those two things is the difference between a legal dispute and a legal outcome you had no say in. The envelope on the doorstep deserves to be opened. What's inside it is a deadline, and deadlines in law do not wait. This video is for general educational purposes only and is not legal advice. Civil procedure rules, judgment enforcement mechanisms, and timelines vary significantly by country, state, and jurisdiction. If you have been served with legal papers, consult a qualified attorney in your area as soon as possible.